So, having heard a lot of this from some very different perspectives, I have to come back to something that Elliot had said, and I'm curious from the panel's perspective. Elliot, you had said that Warner has been very forward-thinking in this area, and I think that's probably true relative to some of the other companies in this space. But one of the questions that I have is, in the world of user-generated content, is anything less than 100% licensing really going to drive a compelling business model? And I mean, Zahav, I'm curious as to your thoughts about this. When users post a video and you've gone through a process of licensing and you have a deal with Warner Music Group, but you don't have one with Universal or Sony as an example, and not to say YouTube doesn't, but just as an example, and there are 30,000 publishers that you need also to have rights with, or you can't even use all of the Warner content that they've made available to you. How do you deal with all of this? Is there a solution to it? Is there a viable business model without getting the others, and is doing a deal with Warner Music Group really do anything in and of itself?
Right, well, so music, a couple things. Warner generally has been forward-thinking in the past, although I have to say that recently I've read some articles that I haven't talked to you about yet, about somebody's idea at Warner Music that their new strategy should be to create scarcity on the web, and actually just license. I can't remember exactly what it was, but I think it was.
Yeah, I think
this is the part where I get quiet.
Well, I think Edgar Bronfman was
I think it was Edgar Bronfman. So
drinking his own product.
that seemed like a change of direction for Warner Music, which I do not think is a wise change of direction, but I'm obviously not running their strategy. So I think that's going to be a very hard objective to accomplish. I mean, theoretically, that makes sense. If you create scarcity, then that you can create high-value deals. But given the technology that's there and available today, I think that's going to be very difficult. But that probably wasn't your idea. What was the other question? Okay, so how do we license? Okay, music is really difficult, and it's really difficult. It's more difficult than other content categories, and that's because, as most of you probably already know, every time you license music, you need to get not just. There's two separate intellectual property rights implicated. There's the sound recording rights and the music publishing rights, which for the composition that's embodied in that particular sound recording. The people that own the two works are often different, and often the people that own the music there's co-publishers. So once you get the sound recording rights from the record label, you may need to track down 3 different co-publishers to get the publishing rights, and you may need to go to one entity to get the right to perform or stream that right to ASCAP or BMI, the performance rights societies, but to a different entity to get the mechanical license to make a copy of that. You might have to, in the United States, you have to go directly to the music publisher. There's 10,000 music publishers in the US, or some crazy number like that, and there's no database anywhere in the world that we can access that will tell us what compositions are embodied in what sound recordings. So in the old days, when you needed to license publishing on a track-by-track basis in order to produce a record of 12 songs, you could hire someone to research 12 songs, and but now in the days of online music access, for a service that needs to license comprehensively all the music in the world, it's not possible, and it's a problem. And
the process, the Copyright Act is still largely set up to facilitate, licensing, the creation, distribution, performance, sort of in traditional physical settings or in physical embodiments of the works. And so it's really messy, it's really painful, it's really difficult in the digital space because there are lots of questions. There aren't efficient processes for getting things licensed quickly, and the digital space is just taking off like a rocket. And there just aren't enough hours in the day to do what is literally required under the current set of laws. I mean, it's a whole nother topic.
Even with all the hours in the world, the information is not even available. It's really.
It is very painful.
Well, and by the way, and I want to pick up on something, and because there's no representative of the music publishers here, I'm going to pick on.
Well, I guess we own one of the largest music publishers in the world, so we represent their.
That is true, but since
I'm not going to blame publishers
on behalf of them. I mean, here this is.
I do.
Zahava, made a very good point. If any of you have dealt with the music publishing situation in the digital space, To call it a nightmare is a vast understatement. Basically, you have a situation where in the U.S., this is not true. There are other problems in different territories, but in the U.S., you have a situation where, and to the label's credits, they don't have to deal with this. When you go into licensed sound recordings, never does Elliott say, even though he takes some very aggressive positions, never will he say that, well, here's what we're charging you for the performance right, and here's what we're going to charge you for the reproduction right. The problem is in the U.S. historically, because as Elliott was noting, and I think this is a vast problem with the copyright law as it pertains to music, there's a separation of organizational structures that license the performance rights as well as then the mechanical or reproduction rights. Because in the old days, you had radio and television or performances in restaurants and bars, and then you had sales of records. Today, on the internet, who's to say, what is a stream? Is a stream a reproduction, or is it a performance, or is it both? I mean, there are cache copies made, there are server copies made. What's happened is the publishers have
Bobby feels very passionate about this
taken
point.
advantage of
right there with
the system. Basically, they said, well, everywhere we can possibly argue it's a reproduction, we're going to take that position because that's Harry Fox. That's where they reign, and that's where they want to make sure they have a seat at the table. The performance rights organizations have taken the other position. Downloads are performances. Now, recently, the ASCAP rate court in May decided I think, in a very proper way, and I think it was a great decision, although it's by far, it's not, it was a summary judgment interim decision that is likely to be appealed, that a download does not implicate a performance right. So, Zahava, when companies like yours are going to license, I mean, Elliot, you had said that these companies these startups in Silicon Valley, get going and then they deal with licensing later. I would ask the question, for small startup companies, is there any possible way they can figure out what they need to license?
No, I mean, it is difficult. I mean, I'm the first to recognize that the copyright law really doesn't facilitate licensing in an efficient way. And needs to be rewritten, and the pain that we all feel is profound. Just, I guess, speaking for publishers, I think they're being rational economic actors. The laws are unclear. It's the digital space. Music is in decline. People are consuming music more than ever before. People love music more than ever before, although many people would argue that the quality of music may not rival the music of the past. The consumption is greater than ever before, yet everybody's suffering. Well, almost everybody is suffering. But this is a chance. This is a new landscape, and it's a chance to reset the table. So, I mean, I find it frustrating too, but publishers are doing what they're supposed to do. They're supposed to, as fiduciators for their songwriters, maximize the pennies they can collect. I don't love the approaches. I hope we get there through legislation and through reasoned discussions and industry agreements. It's just the painful world we live in.
And it's even one. Oh,
I'm sorry, because I wanted to throw in one extra variable in this whole scenario you guys talked about. Just I think 7 or 8 days ago, 10 days ago, Bruce Springsteen performed on the Today Show. And he had some music, then he stopped and he made what I think was a pretty clear political statement. And I would make a strong argument from a media standpoint that perhaps some of what he said during his song was subject to fair use. And by the way, if it wasn't, who would I go to for the license? NBC? Sony?
Well, I don't think,
Bruce?
fair use still exists, right? So, I mean, if it's newsworthy and the 4 factors
Okay, but then I get a 512 takedown notice. What do I do? And who do I get it from?
You say it's improper because you have an exemption from.
Who do I say? You're saying that I send a counterclaim?
Well, you're the one who explained that 512 has a counter.
It does,
provision, so
and how many times it's used? It's onerous. It goes to the question of chilling effect. So we're talking about balance, and I understand everything you've said about the importance of the artist and the creator, and I totally agree. But there's other balances that are involved too. That's sort of what I'm getting at.